Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Commissioner v. Zuch. In this case, the court considered this issue. Does a proceeding under 26 U.S.C. Section 6330 for a pre-deprivation determination about a levy proposed by the Internal Revenue Service to collect unpaid taxes become moot when there is no longer a live dispute over the proposed levy that gave rise to the proceeding? The case was decided on June 12, 2025. The Supreme Court held that the tax court lacks jurisdiction under 26 U.S.C. Section 6330 to adjudicate disputes between a taxpayer and the IRS once the IRS is no longer pursuing a levy. Justice Amy Coney Barrett authored the 8-1 majority opinion of the court. Section 6330 of the Internal Revenue Code grants taxpayers the right to a hearing before the IRS can levy, seize and sell a taxpayer's property to collect unpaid taxes. At this hearing, a taxpayer can raise issues about the levy, including the existence or amount of the underlying tax liability, and the appeals officer makes a determination about whether the levy may proceed. The law then permits review of this determination by the tax court. The tax court's jurisdiction is strictly limited to reviewing the determination whether a levy may go forward, not every dispute considered at the hearing. If there is no longer a proposed or ongoing levy, for example, because the taxpayer's liability has been zeroed out during the pendency of the appeal, there is no determination left to review, and thus, no case or controversy for the tax court to resolve under Section 6330. The reasoning rests on several points. 1. The statutory text and structure focus the collection due process hearing and subsequent tax court review on the levy alone. 2. The default rule in tax litigation is that challenges to tax liability must proceed as refund suits after payment, except where specifically authorized exceptions, like the collection due process review, apply. And 3. The statute does not authorize the tax court to issue refunds or declaratory judgments unrelated to stopping a levy. Therefore, after the IRS drops the levy because the tax debt has been satisfied, any continuing disputes about liability or overpayment must proceed through a refund suit in district court, not in the tax court under Section 6330. Justice Neil Gorsuch authored a dissenting opinion, arguing that the tax court retains jurisdiction over all issues addressed in the IRS's determination, including disputes about underlying tax liability, even after a levy is abandoned, and that stripping jurisdiction in these circumstances creates opportunities for the IRS to evade judicial review and leaves taxpayers without meaningful remedies for erroneous IRS actions. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Barrett delivered the opinion of the court. The tax code authorizes the Internal Revenue Service to levy on, in other words, to seize and sell, a taxpayer's property to collect unpaid taxes. Before a levy goes forward, however, the taxpayer has the right to a hearing at which she can dispute issues relating to the levy. At the hearing, an appeals officer considers the taxpayer's arguments and renders a determination about whether the levy can proceed. If the appeals officer sustains the levy, the taxpayer can seek review in the United States Tax Court. This case presents a procedural twist. While Jennifer Zuch's appeal was pending before the tax court, she overpaid her taxes, and the IRS applied those overpayments against her alleged tax liability, thereby eliminating any justification for a levy. Yet Zuch wanted the appeal to continue. She still disputed the debt that prompted the levy, and she hoped that a victory before the tax court would force the IRS to refund her overpayments. We must decide whether the tax court had jurisdiction to hear Zuch's appeal once the possibility of a levy was off the table. It did not. The typical way to dispute a tax liability is to pay first and then seek a refund. In certain circumstances, however, Congress has given taxpayers the option of prepayment judicial review. A levy is one such exception. When a taxpayer who is liable to pay a tax neglects or refuses to pay the same, the IRS may levy upon all property and rights to property belonging to the taxpayer. But because the seizure and sale of property has serious consequences for the taxpayer, Congress requires the IRS to give the taxpayer an opportunity to request a hearing before the levy is made. In the tax world, this is called a collection due process hearing. An appeals officer in the IRS Independent Office of Appeals conducts the collection due process hearing. At it, the taxpayer may raise any relevant issue relating to the unpaid tax or the proposed levy, such as appropriate spousal defenses, challenges to the appropriateness of collection actions, or offers of collection alternatives. The taxpayer may also raise at the hearing challenges to the existence or amount of the underlying tax liability if the taxpayer did not previously have an opportunity to dispute the tax liability. The appeals officer then makes a determination, which shall take into consideration various factors, including the issues raised by the taxpayer. Within 30 days of the appeals officer's determination, the taxpayer may petition the tax court for review of such determination. The decision of the tax court is reviewable in the federal courts of appeals. In the fall of 2012, Jennifer Zuch and her then-husband Patrick Gennardo separately filed untimely 2010 federal income tax returns. Zuch's return reported no outstanding tax obligations, but Gennardo's reflected a substantial balance due. To resolve this balance, as well as other outstanding tax liabilities, Gennardo submitted an offer in compromise to the IRS. This offer implicated estimated tax payments, totaling $50,000, that the couple had already sent to the IRS. After Gennardo submitted his offer, the IRS applied these payments to his account as a married filing separate taxpayer, thereby settling his debt. A few weeks later, Zuch filed an amended 2010 tax return that reported an additional $71,000 in income from a retirement distribution, generating almost $28,000 in tax liability. But Zuch also claimed that the $50,000 in estimated tax payments should be credited to her account, entitling her to a net refund of about $22,000. The IRS disagreed. Because it had already allocated the $50,000 to Gennardo, it refused to apply the estimated payments to Zuch. Instead, the IRS informed her that it intended to levy on her property to collect what it deemed to be unpaid taxes. Zuch requested a collection due process hearing, at which she asserted that the IRS should have credited the estimated tax payments to her account. The appeals officer rejected her argument and sent Zuch a notice of determination sustaining the levy action. Zuch then appealed to the tax court, which remanded the case back to the Office of Appeals for further factual development. The office sustained the levy, and proceedings resumed in the tax court. The process spanned several years, and on multiple occasions during this period, Zuch filed an income tax return reporting an overpayment that entitled her to a refund. But each time, instead of issuing a refund, the IRS credited the overpayment against Zuch's supposedly outstanding 2010 tax liability. As these credits accumulated, Zuch gradually paid down the balance, and when it hit zero, the IRS moved to dismiss the tax court proceeding as moot. Because Zuch no longer owed any money, there was no longer any justification for a levy on her property. Thus, the IRS argued, the tax court lacked jurisdiction over the appeal from the collection due process hearing. After all, the proposed levy was the hearing's raison d'etre, the tax court agreed, concluding that it had no freestanding jurisdiction to determine an overpayment or to order a refund or credit of tax paid in a Section 6330 proceeding. So if Zuch wanted to recover her overpayments, which would require her to prevail in her long-running dispute with the IRS about her 2010 tax liability, she would have to initiate a refund action. In short, she would have to start over. Frustrated, Zuch appealed to the Third Circuit, which vacated the tax court's dismissal and held that the IRS's decision not to pursue the levy did not moot the tax court proceedings. The Third Circuit reasoned that Section 6330C, 2b, authorizes Zuch to raise challenges to the existence or amount of the underlying tax liability, and Zuch still disputed the IRS's allocation of the $50,000 in estimated tax payments to her ex-husband. And in the Third Circuit's view, a declaration by the tax court in Zuch's favor would not be a dead letter because a declaration might be preclusive in a future refund proceeding by Zuch against the IRS. So while the tax court could not itself order the IRS to give Zuch a refund, it could enter a declaration that Zuch might be able to use to secure one. In reaching this conclusion, the Third Circuit acknowledged that it was parting ways with the Fourth and D.C. Circuits, which have held that the tax court lacks jurisdiction over a collection due process proceeding when there is no longer an underlying levy. The tax court is a court of limited jurisdiction. The parties agree that the only jurisdiction conferring provision applicable here is Section 6330D, 1, which states that the tax court shall have jurisdiction to review a determination made by an appeals officer in a collection due process hearing. What matters then is the scope of a determination under Section 6330D, 1. As the government sees it, a determination is simply a decision as to whether a levy may go forward. If there is no longer a proposed levy, there is no adverse determination of which the taxpayer may seek review in the tax court. By contrast, Zuch argues that a determination encompasses the appeals officer's resolution of all the issues raised by the taxpayer at the collection due process hearing. Here, the appeals officer concluded that the $50,000 in estimated tax payments should be credited to Gennardo. The tax court can still review that conclusion, Zuch insists, even though the IRS abandoned the possible levy. And Zuch contends that if the tax court agrees with her, the IRS would then refund her the amount it had withheld. We agree with the government. The determination in Section 6330D, 1, refers to the binary decision whether a levy may proceed. Section 6330C, 3, which sets forth the basis for an appeals officer's determination, states that it shall take into consideration three things: a verification that the IRS has complied with any applicable law; b. the issues raised by the taxpayer, and c. whether the levy balances the need for the efficient collection of taxes against concerns that a levy be no more intrusive than necessary. The statute thus distinguishes between considerations that inform the appeals officer's determination and the determination itself. In other words, the statute speaks in terms of inputs, the three considerations articulated in Section 6330C, 3A, C, and an output, the appeals officer's ultimate determination. Here, the dispute about Zuch's estimated tax payments was an input into the determination, an issue raised by Zuch that the appeals officer was required to consider. The determination was the appeals officer's decision upholding the IRS's decision to issue a levy. Statutory context also supports the government's interpretation. Recall the default rule. Taxpayers cannot challenge disputes about tax liability without first paying the disputed taxes. Had the IRS offset Zuch's overpayments against her tax bill without pursuing a levy, Zuch's only option would have been to sue for a refund. She was able to depart from the ordinary course only because the IRS proposed a levy, which triggered her right to a collection due process hearing. So, as one might expect, Section 6330 focuses on a proposed levy. The provision is titled Notice and Opportunity for Hearing Before Levy. The notice must occur not less than 30 days before the day of the first levy, and must include information about the levy, such as the statutory provisions relating to levy and sale of property, the procedures applicable to the levy and sale of property, and the procedures relating to redemption of property and release of liens on property. The scope of the hearing tracks its purpose. The taxpayer may raise only issues that pertain to the levy. Given Section 6330's unwavering focus on levies and the default rule requiring post-payment suits, it would be strange if a taxpayer could use a Section 6330 appeal to resolve tax disputes that no longer have any connection to an ongoing levy. Finally, we are skeptical that the tax court has authority to provide any relief under Section 6330E that goes beyond an order enjoining a levy. Section 6330E, 1, authorizes the tax court to enjoin the beginning of a levy or proceeding, but it may do so only in respect of the unpaid tax or proposed levy to which the determination being appealed relates. The provision does not authorize the tax court to order a refund or to issue a declaratory judgment that resolves disputes about tax liability. Of course, as Zuch notes, the authority to issue injunctive relief against a levy necessarily includes the ability to make declarations about the validity of the tax obligations underlying it, but not when there is no levy. Without a levy, the tax court has no authority to render such conclusions. Given these statutory constraints, the tax court properly dismissed Zuch's appeal. The appeals officer issued a determination that the IRS's proposed levy on Zuch's property could go forward. The tax court had jurisdiction to review that determination, that is, to decide whether the levy could, or could not, go forward. As part of that review, the tax court initially had authority to determine whether the appeals officer's predicate conclusions, like whether the $50,000 should have been credited exclusively to Gennardo, were correct. Once the IRS used Zuch's overpayments to zero out the balance she allegedly owed, there was no longer any basis for a levy. Thus, there was no relevant determination for the tax court to review. At this point, Zuch's appeal amounted to a request that the tax court issue an opinion on a disputed question of tax liability independent of any ongoing collection effort. Because the tax court lacked jurisdiction to do so, it was right to dismiss the case. Of course, none of this means that Zuch lacks recourse against the IRS. Like any taxpayer, she may file a post-deprivation suit for a refund, which she has in fact already done. Because there was no longer a proposed levy, the tax court properly concluded that it lacked jurisdiction to resolve questions about Zuch's disputed tax liability. The judgment of the Third Circuit is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Gorsuch, dissenting. Like many Americans, Jennifer Zuch wound up owing money on her taxes. When the Internal Revenue Service told her that she had failed to pay all she owed for 2010, her, then, husband responded by paying the bill. But instead of applying that payment to resolve her liability, the agency used the money to satisfy her husband's separate tax debt. The agency did so even after Ms. Zuch's husband insisted the money was meant for her tab, not his. Then, because it deemed Ms. Zuch's liabilities still outstanding, the agency sought to seize and sell her property in a levy. Ms. Zuch spent more than a decade challenging the IRS's moves before the agency and, later, the tax court. Finally, just as the tax court was poised to rule, the IRS moved to dismiss Ms. Zuch's case. It did not do so because it admitted its mistake in crediting her husband's payment to the wrong account. Instead, the agency told the court it had determined that Ms. Zuch overpaid her taxes in later years, and it had decided to keep, rather than refund, those overpayments to satisfy her disputed 2010 debt. So, the IRS continued. A levy was no longer needed and the court should therefore dismiss the case. The tax court agreed, reasoning that the IRS's decision to drop the levy deprived it of jurisdiction over the dispute. The court endorses that decision. I would not. Ms. Zuch still had a live claim pending before the tax court. She argued that the IRS erred by failing to credit her husband's payment to her tax debt, so she owed the agency nothing for 2010. Had she prevailed on that claim, the IRS would have had no basis for keeping her overpayments in later years. Nothing prevented the tax court from saying as much. Today's decision holding otherwise leaves Ms. Zuch with no meaningful way to pursue her argument that the IRS erred or to recoup the overpayments she believes the IRS has wrongly retained. Along the way, the court's decision hands the IRS a powerful new tool to avoid accountability for its mistakes in future cases like this one. To see where the court and I differ, a little background helps. As many taxpayers know, the IRS can collect unpaid taxes by seizing and selling a taxpayer's property in a levy. But, before the agency can take that step, it must afford the taxpayer an opportunity to request a hearing before the IRS's in-house Office of Appeals. At the hearing, the taxpayer may raise any relevant issue relating to the unpaid tax or the proposed levy, and, if she hasn't previously had the chance to do so, challenge the existence or amount of her underlying tax liability. After the hearing, the Office of Appeals issues a determination. By statute, a determination by an appeals officer shall take into consideration various matters. They include whether the IRS has followed all applicable legal rules, whether a levy is no more intrusive than necessary, and whether the IRS has explained away the issues raised by the taxpayer, which, remember, may include a challenge to the unpaid tax or to the underlying tax liability. Once the Office of Appeals issues a determination, the taxpayer can seek review in the tax court, another administrative tribunal within the executive branch. See Part 3, Infra. Section 6330d, 1, provides that a taxpayer may, within 30 days of a determination under this section, petition the tax court for review of such determination, and the tax court shall have jurisdiction with respect to such matter. If the tax court concludes that the Office of Appeals erred, it may enjoin any action or proceeding, in respect of the unpaid tax or proposed levy to which the determination being appealed relates, or else remand the case to the Office of Appeals for further proceedings. Where should all this leave Ms. Zuch? As the above sketch illustrates, the tax court's jurisdiction over her case hinged on the presence of a timely appeal determination by the Office of Appeals. Everyone agrees we have that here. As we have seen, too, a determination may address whether a taxpayer actually owes any unpaid tax or has any underlying tax liability. Everyone agrees we have that here too, for the determination in Ms. Zuch's case both approved a levy and rejected her argument that she had already fully satisfied her 2010 tax bill thanks to her husband's payment. Those undisputed facts should lead to a straightforward conclusion. Because the tax court had before it a valid determination, it had jurisdiction to review all the issues addressed in that determination, including whether the IRS was wrong to say Ms. Zuch owed money for 2010. Had the tax court ruled for Ms. Zuch on that issue, its decision would have had other important consequences too, for it would have deprived the IRS of its sole justification for keeping, rather than refunding, Ms. Zuch's later overpayments. The fact that the IRS announced its intention to drop its levy is immaterial. Nothing in the statute before us suggests that the IRS can deprive the tax court of jurisdiction simply by withdrawing a levy. To the contrary, three key features of the statutory scheme we have already encountered preclude that conclusion. First, Section 6330d, 1, governs the tax court's jurisdiction. It provides that the tax court shall have jurisdiction over such matter, a phrase that refers back to the Office of Appeals' determination in the taxpayer's case under Section 6330c, 3. That command is mandatory, and it nowhere uses the word levy. The absence of that term is telling, too, given that Congress used it almost 30 times elsewhere in Section 6330. Had Congress wished the tax court's jurisdiction to rise and fall with a levy, it obviously knew how to say so. Congress's decision instead to link jurisdiction to a determination is one we must respect, not allow the IRS to rewrite as it pleases. Second, Section 6330c2 provides that a determination may address not just an up or down decision on a levy, but also other matters raised before the Office of Appeals, including a taxpayer's claim that she has no unpaid tax or underlying tax liability. And, the statute tells us, resolution of those issues forms the basis for the determination, supplying textual evidence that a determination incorporates the considerations that inform it. Confirming as much, the tax court itself has observed that its jurisdiction is defined by the scope of the determination, and, as a result, it may consider challenges to the existence or amount of the underlying tax liability if raised by the taxpayer and resolved by the Office of Appeals. As we have seen, The Office of Appeals' determination in this case expressly addressed Ms. Zuch's claim that she had no unpaid taxes or underlying liability for 2010. Third, Section 6330E(1) grants the tax court the power to issue injunctions against any action or proceeding, in respect of the unpaid tax or proposed levy to which the determination being appealed relates. That disjunctive phrasing suggests the tax court may enjoin any IRS action relating to the unpaid tax even if the action is not a proposed levy. Potential IRS actions relating to an unpaid tax include various collection alternatives, and decisions about whether a tax liability remains unpaid. Accordingly, had the tax court found that Ms. Zuch owed nothing for 2010, it could have wielded its remedial authority under Section 6330E(1) to enjoin the IRS from engaging in any action to collect that debt. An injunction could stop the IRS from asserting its entitlement to retain Ms. Zuch's later overpayments. See Part 4, Infra. Until recently, even the IRS would have agreed with all this. As the IRS once put it, a motion to dismiss is inappropriate in the tax court proceedings as long as a taxpayer, as here, still contests the existence or amount of her tax liability. Nor would it matter, the IRS continued, if the taxpayer had already paid the disputed tax, a development that, pretty plainly, would avoid any need for a levy. At the IRS's urging, the court today upholds the tax court's dismissal of Ms. Zuch's claims. In doing so, the court embraces the agency's present view that the tax court is powerless to resolve a Section 6330 case once the IRS abandons a levy. But the three arguments the IRS advances, and the court adopts, in support of that conclusion do not come close to proving it. The IRS first posits that the word determination in Section 6330D(1) refers to the binary decision whether a levy may proceed. So when the Office of Appeals issues a determination, the IRS says, that office simply decides whether a levy is appropriate. And given that, the IRS extrapolates, the tax court's jurisdiction must also be limited to assessing the propriety of a levy. The statute the IRS imagines is not the statute we have. Congress did not say that a determination refers to a binary decision whether a levy may proceed. Instead, Congress said that the tax court may review the full scope of a determination, including its resolution of a taxpayer's unpaid tax or her underlying tax liability. Congress discussed levies in many other places in Section 6330, and it easily could have said that the tax court may review only a determination whether the levy may go forward. Yet nothing like that italicized condition appears in Congress's work. Next, the IRS suggests that the tax court's jurisdiction must be limited to assessing levies because the only remedy it can issue is an order directing the government not to pursue a levy. Along similar but more restrained lines, the court expresses skepticism that the tax court's remedial authority extends beyond enjoining a levy. Whether full-throated or half-hearted, that argument too disregards the statute's terms. Remember, Section 6330E(1) permits the tax court to enjoin any action by the IRS relating to the unpaid tax or the proposed levy. So if the tax court were to conclude that Ms. Zuch is right, that her husband paid her bill and she owes nothing for 2010, then it could enjoin the IRS from pursuing any action to seek or retain money from her for that tax year or from making any contrary decision about the matter. And, as we have seen, that relief would effectively foreclose the agency from asserting any lawful entitlement to Ms. Zuch's overpayments in later years. The IRS's remedial theory suffers another flaw too. Sometimes, of course, developments during litigation that leave an Article III court powerless to issue any binding relief can present a jurisdictional problem. The Constitution, after all, authorizes federal courts to entertain only live cases and controversies, not moot ones where it is no longer possible to grant any effectual relief to the parties. But, as the court seems to recognize, that constitutional constraint does not apply to the tax court. Name notwithstanding, that body is not part of the judicial branch. Instead, it exercises Article II executive authority as part of the executive branch. So when the tax court addresses a tax dispute and returns it to the Office of Appeals, it is just one executive agency advising another about how to enforce federal law in a particular setting. And even without an injunction compelling it to do so, the Office of Appeals may choose to follow the tax court's views when carrying out its duty to resolve tax controversies, to the maximum extent possible through an administrative settlement. For taxpayers like Ms. Zuch, that may be all the relief they need. Without statutory text on its side, the IRS resorts to legislative history. Citing a committee report, the agency contends that Congress meant for Section 6330 proceedings in the tax court to be rare and few, and for most challenges to the assessment of a tax to be brought in post-payment refund suits or prepayment deficiency actions in federal district court. That background rule, the IRS says, counsels against reading Section 6330 to allow the tax court to entertain disputes after the government abandons a levy. But even if refund suits and deficiency actions were once the usual ways for individuals to contest their tax liabilities, nobody disputes that Congress afforded taxpayers a new way of doing so when it adopted Section 6330. And taxpayers are entitled to expect that provision will be applied as written, not whittled down to a nub to suit the IRS. Recognizing that today's decision leaves Ms. Zuch, after a decade of litigation, without resolution of her straightforward argument that the IRS erred when it concluded she had not paid her 2010 tax bill, the agency invites her to start over. All she has to do, the IRS says, is file a new refund suit in federal district court. There, she can make all the arguments she sought to press in the tax court. And, if she prevails, she can secure a refund of the overpayments the agency kept to satisfy her disputed 2010 debt. But that is no answer. More nearly, it is a trap for the unwary. The reason has to do with a statutory deadline. Taxpayers may not pursue refund suits until they have filed administrative claims with the IRS, something they must accomplish within 3 years from the time the return was filed or 2 years from the time the tax was paid, whichever period ends later. Yet a taxpayer who chooses to contest her tax liability in Section 6330 proceedings may not know that she needs to file such an administrative claim until the time for doing so has passed. Ms. Zuch's case illustrates the problem. The government deemed her 2010 tax debt paid when it kept overpayments she made in 2013 to 2016 and 2019. To seek the return of those overpayments, Ms. Zuch needed to submit an administrative claim with the IRS within 2 years of when the agency kept each payment. Yet for a couple reasons, she did not know that she had any need to file a claim. For one, she was actively litigating Section 6330 proceedings and understandably thought that was sufficient unto the day. For another, it appears the government did not tell her that she had overpaid her taxes in 2013 to 2016 and 2019, or that it intended to use those overpayments to satisfy her disputed 2010 tax liability, until it moved to dismiss her case in the tax court. Consequently, Ms. Zuch had no reason to think administrative refund claims might be necessary, or even available, until that point. And by the time she filed a refund suit in district court, it was too late for her to submit prerequisite administrative claims for some, but not all, of the years in question, and thus too late for the court to adjudicate her entitlement to refunds for those years. So the IRS's invitation for Ms. Zuch to start over really turns out to be little more than an effort to deprive her of complete relief. The short of it all is this. The IRS seeks, and the court endorses, a view of the law that gives that agency a roadmap for evading tax court review and never having to answer a taxpayer's complaint that it has made a mistake. After today, Section 6330 proceedings are essentially risk-free for the IRS. It may pursue a levy and argue its case to the tax court. Then, if the tax court seems likely to side with the taxpayer, the IRS can drop the levy and avoid an unfavorable ruling on the taxpayer's underlying tax liability. Doing so will often prove only a small setback for the IRS because the agency remains free to pursue other collection methods, including keeping, rather than refunding, a taxpayer's later overpayments. And the taxpayer will often find herself without any way to challenge the IRS's error or prevent the agency from keeping more of her money than it is lawfully due. Seeing nothing in the law compelling any of those results, I respectfully dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.